Hello, everybody. Thank you for joining us today for this third session and season finale of our Animal Shelter Law Summer Series. The series is brought to you by the American Bar Association's Companion Animal Law Subcommittee, the Animal Law Committee, and the Tort Trial and Insurance Practice Session. Today's program is on recent developments in shelter law. My name is Madeline Bernstein, and I'm president of the Los Angeles SPCA. Today's presenters are Libby Post and Joan Schaffner, who I will introduce in a moment. But before doing so, I want to share the plan for today's session. The session will run for 1 hour. We'll reserve 10 minutes at the end to take your questions, and you can submit your questions anytime during the presentations through the Q&A feature at the bottom of your screen. Note that today's session is being recorded and will be shared on YouTube and social media after the event. So please keep that in mind when you're framing your questions. With that, I'm going to introduce our first speaker and get right to this. Libby Post is the executive director of the New York State Animal Protection Federation. She lobbies on behalf of the state's shelters and rescues, and the Federation proposed the Companion Animal Capital Fund, which to date has invested close to $50 million in shelter capital projects across the state since 2018. So with that, I'll turn it over to Libby.
Thank you, Madeline. I appreciate it. And I'm sharing my screen. I just want to make sure you can all see it. So yes, you're all seeing the screen. Okay, good. I'm going to go with that. So I'm going to talk about, oh boy, this is not, okay, here we go. So I'm going to just give you a brief overview of who we are and then get right into it. So the Federation is a statewide organization. It was founded in 2010, represents all the animal shelters in the state. We have a growing number of rescues as well. We're a C4, which means we educate, advocate, and lobby. And I work with the legislature, the governor's office, and the Department of Ag and Markets. We have almost 150 members across the state. And we also have a C3, which is our tax-deductible arm. We do Companion Animal Care Standards Act consulting, and you'll hear about that in a minute. We provide low-cost grant writers to assist our members with their Companion Animal Capital Fund grants. We do shelter consulting on major capital projects, and I do board development and philanthropy training. So we've received close to $500,000 in grants from the A, Wiederhold, and New York Community Trust to provide what I call no-cost, low-cost consulting for shelters and rescues to meet the new standards. We have a team of 6 animal welfare professionals, and since we started this, we've worked with over 80 organizations. As we said, the Capital Fund was championed by the Fed. It's administered by Ag and Markets. You have to be in the state financial system. There's a lot of stuff that you have to do, especially if you're a nonprofit and not a municipal shelter. But nonetheless, we help everybody do what they need to do to get in the state financial system. And the RFP that's coming out in the fall is written specifically to the standards. It used to be written to the 2010 ASV guidelines, the Association of Shelter Vet guidelines, and the bill is also written specifically to that. The eligible expenses are direct costs related to construction, renovation, all this sort of stuff, labor performed by municipal employees and project oversight. Eligible expenses are things like HVAC, medical equipment used exclusively for sheltered dogs and cats. You can't pay for medical equipment or facilities used for community or outpatient services, and labor performed by shelter employees are not eligible. Neither is the purchase of land, architect or design fees, or any of these other things. When we do the grant writers, we are very clear. You have to have a budget. You have to have the plans. Otherwise, we're not going to assign you a grant writer. Everyone is eligible, nonprofit and municipal shelters. The grant awards are between $20,000 and $500,000. This upcoming grant round, or the grant round that just was awarded, had $10.6 million, and over 50 organizations applied for more than $18 million in that. The organizational match across the board is only 10%. It used to be a lot higher. And it's not like $500,000 is going to pay for a new shelter, but it pays for a project. It pays for HVACs or kennels or cat condos. Okay, and the fund is there, and there was a method to all of this madness to help shelters with their capital projects to meet the standards. Okay, so the standards are basically a new chapter of law. It's Article 26C of the Ag and Markets Law. It raises the standard of care for homeless companion animals across the state at shelters and rescues. It was passed unanimously in both houses. It was a 25-page bill, and I am convinced nobody read it, except those of us who wanted to see it get passed. We were there with the ASPCA and HSUS. It was our bill, and we said we wanted it, so it got done. Shelters and rescues will be overseen and inspected. Everyone will be overseen and inspected, which is a change from what it is now. Right now, only municipal shelters and shelters with municipal contracts are inspected, and it covers everything from vet care and behavior to transport and the physical plant. Everyone, the law was signed in, it was signed into law December 15th, 2022. It comes into effect this December 15th. We did a 3-year effective date on purpose to give people the time they needed to be able to make the changes that they needed to make, and also for us to be able to do the consulting services. It was one of the selling points to the legislature. All entities in New York will be licensed as animal shelters, and so everyone will come up under this rubric. And again, the fund is there to help people make the changes they need. The overview is this is what the bill contains: the definitions, licensing and inspection, training, record keeping and protocol, facility standards, housing, sanitation, shelter management, husbandry, vet care, behavior, transport, foster care providers, and of course, the violations. I'm not going to go through each and every one of these, but the definitions are clear about, what an adult dog or adult cat means. An animal means dog or cat. And for New York, that's really important because the previous laws, the Chapter 7 of the Ag and Markets Law only dealt with dogs, and cats really weren't seen as anything that had to be dealt with. And so now they will be seen as animals that need to be cared for. And the shelter is a public or not-for-profit entity. Everybody will be licensed, as I said before, with a $150 annual fee. This registration, this fee will supplant the registration bill that we put into place in 2017 so that we could get a handle on who the rescues were. We knew who the shelters were, but we had no idea how many rescues there were in the state, and the rescues outnumber the shelters 4-1. Okay, you have to be a nonprofit organization. You must prove that you weren't a pet dealer in the past. I know people are seeing this all over the country where pet dealers no longer want to be overseen by Ag and Markets or whomever is supposed to oversee them, and they change their corporate structure to be a 501c3 rescue, but using the same business model as before as a pet dealer. You have to prove that you were never a pet dealer. We know who the pet dealers were, so you have to provide proof of incorporation as a non-profit and all of that. And if it's found that you were a pet dealer, you will get kicked out of the program. Training, everybody has to be trained, staff and volunteers with direct animal care responsibilities within 60 days of employment or volunteers designation. Annually after that, it's about the documentation and the paperwork. It's about showing who's been trained and what they've been trained in. They don't have to be trained in every aspect. If someone's dealing with cats, they get trained in how to handle cats. If they're dealing with dogs, same thing. Vets and vet techs are exempt, or they're going to be exempt because we're making some changes to the bill, because they already have to do CEUs of continuing ed in their own right. Okay. And all the documentation has to be maintained for 10 years or for 3 years. It can be webinars, on-site lectures, off-site conferences. We're working with the A. They're putting together a new portal, ASPCA Learn, where we're putting what we have up there. They're putting their stuff up there. We're hoping that other organizations will allow us to put their trainings up there. It'll all be in one place so that people can avail themselves of this. Record keeping and protocols is very important. You'd be surprised, there are some shelters still doing everything by hand, not using any of the cloud-based programs like PetPoint or Shelter Love. All of that needs to be taken care of, and they need to maintain animal registry of the record of the animal for at least 3 years with all these different things. What, who was surrendered, why it was seized, date of intake, date of departure or adoption, the status, behavioral history. Right now, we need to, with this new law, when someone comes to adopt, we have to disclose the bite history of the dog or the cat. Facility standards, this is, to me, some of the most important part of the bill. It's the reason why we have the Companion Animal Capital Fund. It's about disease control. Really, most of this stuff is about disease control. Indoor surfaces have to be non-porous, water resistant, non-toxic, and able to withstand regular cleaning and disinfection. You have to have electrical power and running water at all times, an emergency plan, readily accessible sinks. One of the things you can apply for with the fund, which a number of shelters have, are generators. And so if, climate change is making the weather a little unpredictable, and so if the electricity goes off, a generator will make sure that it kicks back on, and the animals will be cared for. Temperature has to be maintained between 60 and 80 degrees. The animals are monitored, document all the regular maintenance of air handling. One of my shelter said, does that mean my staff has to go into the air handler and see if it's okay? And I was like, no, that's what you hire a professional for. Ammonia levels are kept at less than 2 parts per million. Separate housing for species. Sick animals segregated in isolation. When animals are in isolation like that, you can have cages of cats and dog kennels together. Sound levels shouldn't exceed 85 decibels, and adequate lighting on and off 8 hours of light and darkness. As I said, the animal populations shall be segregated, dogs and cats in the separate rooms, same species, separated by age group. There's specific stuff around nursing moms and how they are housed with their offspring. Animals with known infectious diseases must be isolated. And as I said before, segregation isn't mandated when the animals are in the medical care, the medical suite. Dogs and cats within a week of giving birth or until separation from offspring shall be provided with a whelping box, a solid floor. They can stretch out, do everything that they need to do to take care of their offspring. Primary enclosures, the dogs have to be able to get up, turn around, stretch out, crouch, do whatever they need to do, and not hit a wall. That was really what's important here. We would like to see as many shelters get the guillotine door, for the lack of a better word, kennels, so that the dogs sleep and hang out in the front and eat in the front, and then they can go in the back to defecate and do what they need to do. There's usually drainage there, and it makes it easier to clean the shelters, the enclosures. If the enclosure has 2 more animals, it has to be big enough. Regardless of the size of a room or enclosure, okay, the number of animals co-housed shall not exceed 12 adult cats. So it's good that the ASV guidelines changed in 2023 and not earlier, because the new guidelines say 6 cats and ours say 12. 2 litters of kittens, 5 adult dogs, 1 litter of puppies. Puppies and kittens less than 4 months have to be housed with their moms or with fosters or surrogate moms. Animals can't be outdoors for more than 12 hours, with the exception of free roaming cats under the care of the shelter. And there are some shelters in New York that do have free roaming cats. And the outside primary enclosures, if a kennel is situated where the dogs can go outside, they have to comply with the standards as detailed in the bill as well. Sanitation, very important. You have to be able that your stuff, your kennels, the cat condos have to be able to withstand the use of the cleaning agents. Animals have to be removed, dedicated equipment, cleaning and disinfecting items and surfaces that come into contact, such as bowls and water bowls and food bowls, and all that stuff have to be cleaned. and disinfected, and everything has to be done before a new animal enters as well. Daily cleaning and at least once a week disinfecting. Laundering of all animal beddings in a washing machine with detergent and thoroughly dried. Those kinds of equipment, that kind of equipment is available to be funded under the capital fund. You have to clean the outdoor premises and, of course, appropriate use and disposal of protective garments. Shelter management protocols. Everything has to be clear. There has to be policies, there has to be SOPs. Everything has to be written down and made available to all staff and volunteers. There has to be sufficient staffing to allow adequate time per animal for cleaning and feeding and to meet the minimum socialization and exercise requirements. Animal husbandry, fresh potable water all the time, a complete and nutritional balanced, species-specific and life stage appropriate diet, feed at least once daily adults, at least twice daily for those that are 6 months or less, and then 3 times daily for animals less than 2 months. There are some shelters that feed their animals, their adult animals twice a day, and I've gotten questions, does this mean we have to only feed them once? I'm like, no. If you want to feed them twice, you can go right ahead, but this is the minimum. They have to refrigerate all the perishable food. Under order of a vet, frightened animals may be appropriately tranquilized. No physical force is to be used as punishment. No adverse behavioral techniques. And I'm actually having a Zoom with Ag and Markets tomorrow to talk about what specifically that adverse behavioral technique, what that means. So restraint devices and handling techniques shall be minimized animal stress and risk of injury to the animal and shelter workers only if necessary. And of course, everything has to be maintained in a good working order. Vet care, everything has to be administered under the supervision and advisement of a vet. In New York, vet techs and trained staff can give immunizations, but a vet has to be there and supposedly give the rabies vaccine. Because rabies is a public health issue, it has to be done with a vet, under the supervision of a vet, because that data has to then go to the local county departments of health. All incoming animals have to be assessed within 2 hours after intake, and then provide a veterinary assessment and humane care in a timely fashion, either in-house or off-site. We know we had this as like 48 hours or 36 hours, and the smaller shelters in the more rural areas in New York State said, we can't do that because there are not enough vets. In Wyoming County, for example, there are 3 vets and they're all large animal vets. And so they would have to go out of the county to get these exams done. So we made it, instead of a specific time frame, we said within a timely fashion. You have to treat acute and chronic pain. Legal status of the animal should not prevent treatment to relieve suffering. So in New York, when a stray comes in, it's put on a 5-day hold. It's still seen as an owned animal until the 5-day hold is up, and then it becomes property of the shelter. Then the shelter can adopt it out. But if an animal is suffering, it doesn't matter what the status is, we can take care of the animal. A complete physical exam by trained shelter staff within 24 hours. As I said before, core and rabies vaccine administered by vet or vet tuck under a vet supervision. We do know that there are trained staffers who also do this. You have to treat for hookworms and roundworms prior to release or placement in foster care. Regular grooming. Our goal is that no animal will leave to be adopted unless it's spayed or neutered. Now, in New York right now, if you take an animal that's not spayed or neutered, you have to give a $35 deposit to the shelter and then come back with proof. And then you get your $35 back. Well, that really doesn't work. I wanted it to go up to $500, but people were like, no, that's a bit much. So it's going to increase to 100, but all the shelters and rescues are really working towards the goal of no one leaves without being spayed or neutered. Okay. You have to do the permanent tattoo to show that the animal's been spayed. And the shelters provide the adopters with instructions on how to care for them. For transport, the origin shelter shall examine each dog and cat for medical and behavioral concerns within 24 hours prior to transport. Everything is recorded and communicated. I'm sure in all the various states, you need a CVI if they're going over state boundaries, the certificate of veterinary inspection. There needs to be the health record, that health certificate, and each animal identified with a collar, a tag, a tattoo, a microchip, or a combination thereof. Vehicles and operators have to adhere to all the applicable federal, state, and local laws. No animal shall be placed unconfined or untethered in the back of an open pickup or a flatbed truck. That sort of just makes sense. All animals have to be confined in an enclosure, such as a crate, a carrier, or a cage, and there has to be adequate space, comfortable environmental conditions, and good air quality. So you can't put it in the back of a van, stack them one on top of the other with no air conditioning. That won't work. The other thing is no shelter or its agency shall transport any dog or cat less than 1 year of age whose point of origin is any breeder licensed by the USDA. We have passed the puppy mill pipeline bill here in New York. It passed the same day as the standards bill came into effect last year. And we have found that there are some organizations, some of those 501c3 organizations that were pet dealers and are now quote unquote rescues, as well as some organizations that have been large shelters for a very long time, were going to the puppy mills, paying for the animals under the guise of rescuing them, bringing them back into the state. There was a puppy mill pipeline train. They came up to New York, upstate New York. I get calls. I just got this dog. It came from X, but it's got parvo. What do I do? And so I had to say, be prepared to spend a lot of money and that there's not necessarily going to be a good outcome. Things are better now, but still, that there is that case of parvo and that a dog won't survive, especially a puppy. So this was one more way for us to shut down the puppy mill pipeline into New York State. And we've gotten a little bit of pushback on it, but not that much. Foster care providers. A lot of the fosters were concerned. What are we going to do? How do we have to do this? We are actually having a webinar next week with Ag and Markets. Over 150 people have already signed up specifically to foster care providers and what they have to do to comply with the standards. Okay. Basically, there's nobody can operate as a foster care provider without having a signed agreement with the shelter. They operate as a foster care provider with the approval and responsibility of the shelter. A copy of that agreement is kept at the shelter and has to be made available if asked for by the Commissioner of Ag and Markets. They don't own the animal. The shelter facilitates the adoption. They have to keep a copy and maintain a record of the animal. They have to protect the identity of the source of the animal. This is usually in a domestic violence situation where shelters have safe haven programs. The women, mostly women, 95% are women who come in. We have found that a lot of women don't leave because of the animals. This way they feel they can leave. The shelter will take the animal for them, keep the animal. Many of them go to foster so that the identity of the woman is protected as well as the animal. Any foster animal affected by an infectious or contagious disease has to be handled in a way where disease isn't spread. That's the basis of the bill. If you have more questions after today, I'm going to make this PDF available. I'm going to send it to the folks at the ABA and they can send it out to everybody. But these are, you can contact me or Barbara Carr, who is running our shelter consulting services. She was the ED at SPCA serving Erie County for many, many years and works with the Fed and the Education Fund to make this stuff happen. So I'm done. I don't know if we want to open it for questions or just have it go over to Joan.
Hi, we're going to save questions for the end. And that was a great presentation. It's really important that the funds can be coupled with the desire to make everything more humane and cared for, because you can tell people what they have to do all day long. They don't have the funds to do it. It's not
Right.
going to work.
There was a method to this madness.
Yes. So thank you. So thank you very much. Our next speaker is Joan Schaffner. She's a professor and faculty co-director of the Animal Legal Education Initiative at the George Washington University Law School. She's the author of Introduction to Animals and the Law, several book chapters and journal articles on animal protection law, and is the past chair of the ABA TIPS Animal Law Committee. And this month, Joan celebrates as editor the release of the Elgar Concise Encyclopedia of Animal Law. So with that, I turn it over to Joan.
Thank you, Madeline. Hello, everybody. It's really a pleasure to be here today with all of you as part of our ABA TIPS Animal Law Committee Shelter webinar series. I want to say that, Libby, that was a great presentation. Congratulations on that wonderful program. And I also want to say that the first two programs in this shelter series have been terrific. And I'm hoping that you're enjoying this one today as well. You all see here, if anybody knows me, you're not surprised that I have a cat here with me. I want to introduce you to Mickey. And Mickey is the newest member of my very large feline family. I basically live in a feline sanctuary. And he just joined my family 2 weeks ago. And his timing could not be perfect. Because as you're going to see, there's another reason that I'm introducing him to you, and that is because he is basically the subject of my discussions today. Let me just change my background here really quickly because it's not much to look at, but you're looking at the slides anyway, so that's perfectly fine. Anyway, in March, I just want to give you a quick case study here concerning Mickey. In March of this year, Mickey appeared for a short while in the yard of a caring woman in Northeast DC, where I live, who feeds a group of community cats. He wasn't welcomed by the existing cats, and he took off. Then 4 months later, on about July 23rd, he returned to her home, talking up a storm in her backyard, very vocal, and not doing particularly well. As you can see from the picture there on the slide, he had a very large abscess on his face, and it seemed to be apparently from fights that he was having with other cats. And he was also fairly skinny for a big boy. On July 24th, the finder picked him up, literally as I just had him, placed him in a carrier, and took him to DC Animal Control here. She explained that he was very friendly. He was clearly not doing all that well on the streets on his own, and asked if they would take him in for adoption. So the shelter did take him in. They listed him in their records as very sweet and friendly. It's right there in the records. And they administered a dewormer, revolution, rabies, and FVRCP vaccines, and then assessed him as meeting the criteria for return to field. They gave him the antibiotic Convenia for his abscess. They neutered him, and then on July 26th, they returned him to his outdoor home. He came immediately back to the finder's yard, again, meowing up a storm, and she decided that he probably should would like to be in an indoor home. So she posted his story to DC Community Cat Facebook page that I sort of follow. I replied to her, and I offered him a home here. This story provides the perfect case study for the San Diego Humane Society community cat case, which is really the subject of my talk today, where the plaintiffs filed a suit against SDHS, claiming that the shelter's return to field of such a cat, a friendly cat, through their community program violated California state law. The statement of decision was issued on June 9th, and the judgment consistent with that statement was issued on July 30th, again, just 2 weeks ago. And that's what we'll be discussing today. Slide number 3, please. So I do want to today focus on community cat programs that are run by public shelters and the implications of this decision on cat intake. Of course, this decision is a trial-level decision in San Diego that addressed only state law. They didn't look at any local law or potential contractual obligations otherwise that the shelter had. and thus it has no real binding effect, right, beyond this case. But it is the only decision to date that addresses the legality of these programs, and thus it may at least be referenced by other judges who find themselves addressing this issue in their jurisdiction. So I'm going to briefly discuss the history behind these community cap programs, or CCPs, and why they're necessary. I'll then turn to the San Diego case, describe the specific parameters of their CCP, the challenges that were raised by the plaintiff, who at the time of trial was the Pet Assistance Foundation, and the court's decision. And then I'll end with some final thoughts about the decision. Slide number 4, please. So let's begin with a bit of background on community cap programs. The practice of trap, neuter, return began here in the US really in about the early 1990s as a compassionate approach to managing the population of free-roaming, unsocialized, often referred to as feral cats. Well, this was controversial with some folks who argued that we should not allow any free-roaming cats, right, and still is with some people, because they may kill birds, they may transmit disease, or they are a nuisance in the neighborhood. But the traditional trap and kill approach to management had not been, and generally isn't, all that successful. And these TNR programs were primarily run by private organizations who cared for the cats, did not want to see them killed when they were trapped and brought to the shelter because they were not adoptable, but who also agreed that reducing their population outside was necessary. So over the years, some jurisdictions began to officially recognize trap, neuter, return in their laws, and some public shelters then began to either partner with TNR organizations or initiate their own return to field programs, whereby the shelter would do the neuter and return itself, typically though for unsocial free-roaming cats that were brought to them for intake. In much more recent years now, these programs have expanded. We're now calling them community cat programs, CCPs, and they can involve the possible neuter and return of any healthy free-roaming cat that's brought to a public shelter for intake. Slide number 5, please. There are several reasons, right, why any shelter would want to embrace a CCP, including one, the large population of free-roaming cats. Currently, they're estimated to range between 50 and 100 million in the United States. The fact that only about 3% of all cats nationally in shelters are reclaimed by their owners, and thus they have a better chance of being reunited with their owners if they don't enter the shelter system. There's, of course, inherently limited space in each of our shelters, and approximately 2.9 million cats entered US shelters in 2024. And the fact that, of course, cats tend to have a poor quality of life in the shelter, and we have a desire to avoid killing healthy and treatable cats. So, slide number 6. Let's now discuss the basic parameters of the San Diego CCP at the time of trial. First, definitions. The CCP divides free-roaming cats into 2 categories as a function of their ownership status. A stray cat is a cat with a verifiable owner who has been abandoned or lost. They then define a community cat as a free-roaming outdoor cat with no verifiable signs of ownership. At the time, to meet the verifiable ownership requirement, the cat was required to have had either a collar with or without an ID tag, have a microchip that was registered to an identifiable owner, known to be recently abandoned by the cat's owner, or be altered without an ear tip, although this alone would not disqualify the cat from entering the CCP. Slide 7, please. The status of the cat determined their treatment when presented to the shelter. Stray cats would be admitted to the shelter. Community cats, however, would follow this protocol. They would be medically evaluated for good health, meaning that the cat has a body condition score of 4 or above. They could walk, run, eat, hear, see, and climb with claws normally, and they had no medical condition that would prevent return. In other words, a condition needing extensive intervention requiring 3 or more days. So if the cat was medically unhealthy, it would be admitted to the shelter. But if they were medically healthy, they would be vaccinated, sterilized, ear-tipped, and returned to their outdoor home. Slide 8, please. So let's now turn to the claim that was brought by the plaintiff, Pet Assistance Foundation, that challenged the CCP as it applied to both friendly cats and kittens. The plaintiff claimed that returning these friendly cats, those cats who are good candidates for adoption and for whom living outside may be especially risky to their well-being, as well as kittens under the age of 6 months, to the outdoors without a registered caretaker legally responsible for them, violated California law. It was an unlawful business practice under Business and Professions Code 17,200 for 2 independent reasons. First, such cat is an abandoned animal, and thus the shelter must take them in under California Civil Code 1816C. And second, returning a friendly cat to the street constitutes willful abandonment under California Penal Code 597S. So let's now see how the court evaluated the lawfulness of the CCP. Slide number 9, please. Since the statute doesn't define abandon, the court referred to Webster's New Dictionary definition that defines abandon as, quote, to relinquish or give up with the intent of never again resuming or claiming one's right or interest in, to give up absolutely, right? The judge stated that for a cat to have been abandoned under 1816, right, they must have had an owner, someone claiming a right or interest in that cat at some point. And then when read together with the abandonment statute, the 2 statutes require that the San Diego Humane Society must admit to the shelter cats with sufficient indications of ownership, whether current or recently past. As to the cat's temperament, at trial, evidence was presented that a cat's level of socialization to humans can be difficult to evaluate in a shelter environment, does not necessarily reflect a cat's ability to live successfully outdoors, and does not necessarily correlate with a cat's ownership status. Instead, for example, a friendly cat may in fact fare well living outdoors because friendliness can indicate that the cat has caretakers that they regularly interact with. Based on that, the judge held that whether the cat is friendly or not is not determinant of whether the cat was abandoned by its prior owner or whether the San Diego Humane Society engages in willful abandonment when returning such a cat to the outdoors. Slide 10, please. Thus, the critical question in determining whether the CCP was legal is whether the cat is owned. And here the judge held that the shelter's verifiable ownership requirement that they had at the time of trial was too stringent. The court noted several objective factors that were relevant to this inquiry: the sterilization status, the presence of a microchip, collar, or other articles of clothing, indications of recent medical treatment, and the corroborated firsthand observations of the person who has brought a particular cat to the shelter. Thus, the court found that cats with non-registered microchips and sterilized cats without ear tips should be deemed owned, although they were not considered so under the original San Diego Humane Society criteria. However, in February 2025, well before the decision in this case, San Diego Humane Society changed their criteria for indicia of ownership, which the court then held in its decision complies with the court's notion of sufficient indicia of ownership. And here are the following factors: that the cat has a microchip, registered or unregistered, that the cat is sterilized without an ear tip, that the cat is wearing clothing or accessories, that there is a clear indentation around the cat's neck, indicating the recent presence of a collar, that there are signs that the cat has recently received veterinary or medical treatment, or based on consideration of all the available information from the finder, the staff, right, the shelter staff determines that the cat has or had an owner. And they provide these two examples. For example, the finder came upon the cat who was confined in a box or a carrier without an owner around, or the finder observed, literally, a person abandoning the cat, okay? Thus, if the cat meets one of these criteria, they are owned and must be taken into the shelter. Otherwise, the cat may be returned to their outdoor home. Slide number 11, please. The court further determined that the original San Diego protocols for kittens were too restrictive, and that they should err on the side of admitting kittens given their more fragile state and lesser ability to thrive on the street. Again, after trial, San Diego had also modified their kitten protocols, and the court held that they now met the standard. And those protocols are as follows. First, the indicia of ownership for cats applies to kittens, and kittens under 12 weeks of age must be admitted to the shelter, whereas kittens between 12 weeks and 6 months are routed based on their sociability and thus adoptability, either into the shelter or into the CCP and returned where they were found. Slide number 12. So that's the bottom line. Interestingly, if you're hearing the parties talk, both parties sort of won in part and lost in part. Thinking about this from the plaintiff's perspective, the plaintiffs won in part by securing a more comprehensive list of sufficient indicia of ownership than what San Diego Humane Society originally was using, right? That obviously are going to include more cats and kittens than were originally covered by their original protocols. However, the plaintiffs lost on their primary argument that friendly cats, right, cannot be routed into the CCP, meaning that the temperament of the cat should be taken into account and be an indicia of ownership. And essentially, right, the court found that the temperament of the cat is really irrelevant to the issue of abandonment and relatedly their ownership status. To be honest, I've been thinking about this result for a while, and again, showing you Mickey here, I remain a little unsure as to whether that was, as a matter of fact, the right decision. I do want to say that there was expert testimony by Dr. Kate Hurley, who is a pioneer in shelter veterinary medicine, the winner of the 2025 AVMA Animal Welfare Award, indicating, right, that the cat's temperament does not reflect a cat's ability to live successfully outdoors and does not necessarily mean that they were owned. So, and who am I to disagree with Kate Hurley on these issues? But I will say that based on my living with many cats over the years, I would argue that if a cat presents as friendly when they have been trapped outside, likely by a stranger, brought to the shelter, clearly a stressful place for the cat, right? Then that cat very likely had been socialized, probably at a relatively young age, which would generally mean that they were previously owned. Yes, cats on the street sometimes, of course, can and do develop a relationship with their caretaker and are friendly perhaps with them. But often that friendliness is specific to their caretaker and they're not necessarily friendly to others. I do also appreciate, right, that it is difficult to determine a cat's temperament. And this is true, but shelters do track this information. Mickey's records from the shelter indicated that he was clearly sweet and friendly. And of course, if it's unclear, then the shelter could certainly err on the side of finding that the cat is not friendly. But if it's clear that the cat is friendly, then perhaps at least it should be a factor in deciding the cat's ownership status. And moreover, if the cat is very friendly, they arguably are a good adoption candidate and might be happier living in an indoor home. The problem, though, is that the alternative, right, for such friendly cat, if it is deemed an indicia of ownership, is that they must be then intake to the shelter, which, as we've already discussed, has its own set of risks. As a theoretical matter, right, animal shelters are supposed to provide shelter to domesticated cats and find good homes for them. As a practical matter, animal shelters are not always able to do this, especially if they're not given the necessary resources. I mean, I worry that some shelters might use their own operational failures as justification for refusing to accept certain cats. But until we have laws and policies that provide the necessary resources to animal shelters and that prohibit the killing of healthy and treatable animals under their care, then I think I've come up that the result in this case, at least as a policy matter, is arguably the right one. I want to briefly, slide number 13, please. Um, on the policy front, I want to briefly mention a program that's in Loudoun County, Virginia, that might alleviate some of these concerns that the plaintiffs and I may have with respect to these friendly cats. I don't know if any of you have heard of their tag program. It's a program that's targeted to healthy social adult cats who otherwise lack an indicia of ownership, but who likely are owned pets. And when such a cat is brought to the shelter, what they do is they place a collar on the cat to alert a potential owner that someone is concerned that their cat is homeless. And then they have the finder return the cat to their original location. The cat's photo is posted on the shelter's Found Pet webpage, and the finder is given a customized found cat set of yard signs and flyers to post around the area. If no one responds after 5 days and the cat is still in the area and appears to need assistance, then the finder may bring the cat back to the shelter, and then the shelter will intake that cat. Slide number 14. I want to note that Loudoun County does not have a community cat program. And the reason is that the Virginia Attorney General in 2013 issued an opinion stating that Virginia public shelters could not return feral. The issue in that case was returning feral cats to the street. They found that it violated Virginia state law. So sort of as a brief comparison with how the San Diego judge addressed this, the Virginia Attorney General, right, basically looked at their law, which first says no person shall abandon any animal, and then defines abandon as desert, forsake, or absolutely give up an animal without having secured another owner or custodian for the animal, or by failing to provide the elements of basic care for a period of 5 days. Fairly broad definition, right? Moreover, under Virginia law, any animal confined in the public shelter could only be disposed of by release to another humane agency or adopted to an individual. So without any analysis at all, the Attorney General quoted these statutes and then held that based on those statutes, a public shelter may not return really any cat, but in this case, feral cats programmatically back to the location where they were trapped, as it would be deemed abandonment under their law. You know, ironically today, now the unsocialized cats in Loudoun County brought to the shelter must either be admitted and then likely killed because they're not really adoptable, or placed back on the street with no veterinary evaluation, sterilization, or vaccination. Slide number 15, please. I think the better argument here, and I just wanted to discuss sort of a different approach to this notion of abandonment, because again, every state and locality have different definitions. But one of the things I think we have to keep in mind when we're interpreting the text of a statute is it should be interpreted in light of legislative intent and purpose of the law and to avoid absurd results, right? So you think about it, the cruelty statutes where the abandonment statute resides, right? They're designed to penalize persons who are intending to cause harm to the cat. Of course, proponents of TNR and CCPs are working to improve the health of the cats while controlling the free-roaming cat population. These cats, as we said, are given a veterinary exam to ensure they're healthy. They're sterilized, which reduces the stresses of mating and pregnancy and can prevent certain feline infections and cancers. And they're vaccinated to protect cats from disease. Thus, the cats are returned in a healthier condition than when they were trapped. And finally, these programs are better than the alternative, especially for the feral cat, who are going to be trapped and probably killed in the shelter because they're not adoptable. So to find, right, that the more compassionate alternative violates state cruelty laws seems to me a bit absurd. So those are my thoughts on the decision. I'm happy to answer any questions. I think we have 10 minutes for those questions. And I'll shift to slide number 16 and say thank you very much. and just mention that those 4 adorable cats were the original 4 cats who are also behind me that started me on this process of living with felines in my home and caring for them. Thank you very much.
Thank you. That was fabulous. I have, while we're waiting to see if there's questions in the Q&A, it's Joan, it just seems that there's a higher standard on the Virginia Attorney General's opinion for the shelters and possibly rescues and possibly anyone who is setting themselves up as a shelter, that their, higher standard of not to abandon is greater than a person who just turns his cat loose. And then part 2 of that question is, do you have any results of the TAG study to see if it's working?
Thank you. Yeah. I mean, yeah, this question of abandonment has been around for quite some time. Interesting, there's very little, if any, case law on it. I was checking again, and no judges are really talking about it. The Attorney General's opinion is sort of the only real official decision, official, if you will, decision on that. But a lot of folks use this notion of abandonment because the other question is when you become an owner, right? Because as you saw with the California case, the focus was on the cat had to be owned. Note that the court didn't say, oh, once San Diego has the cat, they're the owner, and now they're owned, right? The court didn't go there, right? Some courts think of that, right? Now, once you've got the cat, now you're the owner of the cat, or you're in possession of the cat, and then once you leave them, you've abandoned them, and with the notion of abandonment being, well, you leave them back outside, you don't give them anything, they're abandoned, sort of, again, as a purely textual matter. Like I said, I think the better argument, though, if that comes up, right, is that you don't always just read the text purely in light of the text, but you have to think about the intent and the purpose behind the law itself. And I think there's, I know, Best Friends, they actually submitted a memo to the Texas Attorney General, just to bring another state into play here, a couple of years ago, was considering the question of whether this would be legal in their state, in Texas. It turned out the Attorney General never issued an opinion because they actually got legislation that allowed for TNR in the state. But like I said, I know Best Friends issued a memorandum, and a lot of folks are saying, the better alternative here is no matter what your abandonment statute says, really, this should not be deemed abandonment when you've got people who are trying to help the animals, putting them back on the street. And that, but, we talked about this before too, Madeline, this is just the abandonment statute, right? We're not talking local, there may be local laws that have other requirements, especially when you're dealing with shelters, right? Are there specific requirements of the shelter vis-a-vis private organizations? Because those two entities may be different, have different footing depending upon how the court's going to interpret the various laws. And, right, if you have a contract with the government, right, that contract may hold you to certain standards with respect to shelter intake of cats or dogs or whomever. And of course, you have to determine whether the contract requires, or either requires that you intake the animal or allows you to return the animal. So, as a legal matter, we're obviously not offering any legal advice here on this webinar to anybody in particular. But as you're seeing, there's a lot of different ways. There's a lot of different laws that can apply, and there's a lot of different ways to interpret them. Just very quickly on the Loudoun County TAG program, a study was done for the first 18 months of that program, and the study was just released this year. And I just want to say, I mean, just to give you some ideas to how the study worked, during the first 18 months of the program, 32 cats were enrolled in the program, and they found that 10 were actually, their owners got them back because they went back home. 4 were kept by the finder. 2 were rehomed by the finder. 6 ended up being returned to the shelter, and of those, 1 was reunited with their owner and the other 5 were adopted. And then 10 of the cats, their disposition was unknown, okay? So the one thing that, this does suggest is, number one, the program helps manage shelter intake because all but, 6 of the cats did not have to be intake into the shelter. So that's a good thing. I'm a little concerned because I don't know what happened to the cats that they don't know what happened to them. But that's a relatively small sample of 32 cats, right? But that's, at least it's, it's sort of a in between, with respect to allowing them to be returned to the shelter if necessary. So,
There's another question in the chat I'm going to
oh
give
yeah,
you,
I'm
but it
sorry.
is interesting that the finders had a serious conscience episode of needing to turn those cats that they found to other owners, which is typically what you associate, the shelter with. So I just thought that, that was kind of interesting. Somebody here,
Yeah, I don't think it matters if the person has passed away.
okay,
The cat would still be deemed owned because, this is the first thing the court said was, because you could argue, well, the cat's on the street now, they're not owned now. They've been abandoned. Once you're abandoned, you're sort of no longer owned. And the cat said, well, the court said that can't be sort of the answer here because then nobody would be deemed owned and you could never have an abandoned animal, right? So it has to be someone who at one point, at least recent past, had been owned. And I think, like I said, the status of the owner, I think, is irrelevant to whether the cat was in fact owned or not. And so, yeah, if the cat's owner, if I'm reading it correctly, I read it quickly, if they, I think ownership clearly would exist even if the owner has passed away, which would just mean that they have to bring the cat in. And, to think about this just as a practical matter, the reason we're looking at ownership, right, is if they were owned, from my perspective, right, I'm thinking if they're owned, then they're used to being indoors in a home and they need to be, for their own well-being, right, they need the shelter and they need to be adopted by a new owner for their own health, right, independent of their owner's interest, right, in necessarily getting them back or not getting them back. But and that's why I think the plaintiff's concern about friendly cats, right, was sort of in the same vein, is they don't think that they're necessarily, just accustomed to being outdoors if they had been owned, and if they're friendly, then they probably were, and thus their life on the street may not be as, as thriving as we think it should be. But it's these are very difficult and controversial questions, no doubt about it.
Right. A lot of contortions in place to reach different results. Libby, I want to give you an opportunity here for a second to say, is there anything you would change? You've got this gargantuan amount of money and you're trying to upgrade all the shelters to do things that they probably haven't done before, with these ASV standards and stuff. Is there any lessons that you're learning or cautions or something you would change right now that it's starting to gel? We should have done this, we should have done that, or this was a mistake.
I don't think that there's a mistake in what we've done. I think what we're hearing is this notion of, why are you making us do this? And my attitude is, this is based on standards that have been around for 15 years. What have you been doing? Right? So when people start complaining, and I'm hearing from people, oh, this is going to shut down shelters and this, that, and the other thing, and smaller rescues and blah, blah, blah. I'm like, first of all, that's not the goal here, right? Ag and Markets, I'm on the working group with Ag and Markets on this. The first year is a learning year for everybody. Shelters, rescues, inspectors, the whole 9 yards. No one's getting dinged, nobody's getting shut down. What Ag and Markets wants to see is progress. So here we have the opportunity to give people this consulting services, which gives them a roadmap of what they need to do. All we ask is that they pay for reimbursable expenses of travel. Otherwise, everything is for free, and they get a tremendous amount of resources by people who have worked in the field for years. And so it's the fear factor here that I think people just need to step back from and recognize this is for the animals. That's what this is about. And the money is that this is the only fund in the nation that does this. There is no other state with a companion animal capital fund. And the governor loves it, and the legislature loves it. And so, we're going to continue to have this funded ad nauseum because it's in the governor's budget. So, somebody wrote about how do you build the relationships. that's what this is all about, building relationships. This is all about knowing who's who in the legislature, who likes animals, who can be your champion in each house, understanding the politics. In New York, everything's controlled by the Democrats now. When we first started, the Senate was Republican, then 2018 happened, the blue wave, and that was the end of that. You know, but the number 2 in the Senate loves animals. He sponsors a lot of our bills. In the Assembly, we have 3 or 4 members who are really, gung-ho on animal stuff. And so we just work with those people, you build the relationships, and you don't do pie in the sky. You do things that are reasonable and achievable.
Well, that's excellent advice. I'm seeing that we're just about out of time. And I think if you put questions in, I believe the ABA will be able to push them out to the relevant speakers. So at this point, I want to thank you so much. Libby and Joan, you're both rock stars. These were great presentations, and I think we could debate them for hours afterwards and analyze them just over and over again. I thank all of you for joining us today, and we're grateful to everyone at the American Bar Association and our committees who helped put this together for you. So with that, I think we're wrapping up. So
Thank you. It was
take
great seeing
care.
everybody today.
Thank
Bye-bye,
you.
guys.
Nice
Bye-bye.
seeing everybody.